Welcome to another lesson on management. Today's lesson deals with the powers and duties of the managing director. This lesson will not only enlighten you about the various qualifications required in order to be appointed as the managing director, but also inform us about the job areas and authority of the managing director. In addition, the lesson also explains the different classification of meetings. I am Amrita Ghoshkumar and the subject expert for today is Dr. Seema Wali, teaching in the Amity University. Subject to the superintendent's control and direction of the board of directors, the day-to-day management of the company shall be in the hands of the director or directors appointed under Article 185A. The directors may from time to time entrust to and confer upon a managing director or whole-time director for the time being saved as prohibited in the Act. Managing Director, Clause 26. A managing director as defined in Section 2 of 26 means a director who is entrusted with substantial powers of management which would not otherwise be exercisable by him. The substantial powers of management may be conferred upon him by virtue of an agreement with the company or by a resolution of the company or the board or by virtue of its memorandum and articles. He is also removable the same way as he was appointed, irrespective of the fact that his appointment has been approved by the central government. Managing or whole-time director, link with nature of duties, not designations. Whether a director is to be regarded as a whole-time director or as a managing director of the company would depend on the nature and extent of the duties entrusted to him, and that the designation under which the appointment is made would not make any difference in this regard. The appointment and remuneration require approval of shareholders in general meeting. The auditor of the company or company secretary has to certify that requirements have been complied with. A return of the appointment in a prescribed form must be filed with the government within 90 days. The following cannot be appointed managing or whole-time directors. 1. A person who is an undischarged insolvent or has at any time been adjudged insolvent. Number 2. A person who suspends or has at any time suspended payment to his creditors or makes or has made a composition with them. Number 3. A person who is or has been convicted by a court of an offence involving moral turpitude. Broadly, meetings in a company are of the following types. 1. Meetings of members. These are meetings where the members or shareholders of the company meet and discuss various matters. Members' meetings are of the following types. A. Statutory meeting. A public company limited by shares or a guarantee company having share capital is required to hold a statutory meeting. Such a statutory meeting is held only once in the lifetime of the company. B. Annual general meeting must be held by every type of company, public or private, limited by shares or by guarantee, with or without share capital or unlimited company, once a year. Every company must in each year hold an annual general meeting. In the case there is any difficulty in holding any annual general meeting, except the first annual general meeting, the registrar may, for any special reasons shown, grant an extension of time for holding the meeting by a period not exceeding 3 months provided the application for the purpose is made before the due date of the annual general meeting. The following matters constitute ordinary business at an AGM: consideration of annual accounts, director's report and the auditor's report, declaration of dividend, appointment of directors in the place of those retiring, appointment of and the fixing of the remuneration of the statutory auditors. C. Extraordinary general meeting. Every general meeting, that is meeting of members of the company other than the statutory meeting and the annual general meeting or any adjournment thereof, is an extraordinary general meeting. An explanatory statement of the special business must also accompany the notice calling the meeting. The notice should also give the nature and extent of the interest of the directors or manager in the special business. The members of a company have the right to require the calling of an extraordinary general meeting by the directors, or if the company has no share capital, the members representing not less than 1/10 of the total voting rights at that date in regard to the said matter. The requisition must state the objects of the meetings and must be signed by the requisitioning members. The requisition must be deposited at the company's registered office. If for any reason it is impracticable to call a meeting of a company other than an annual general meeting, or to hold or conduct the meeting of the company law board may either 1. On its own motion, or 2. On the application of any director of the company or of any member of the company who would be entitled to vote at the meeting, order a meeting to be called and conducted as the company law board thinks fit. An application by a director or a member of a company for this purpose is required to be made to the regional bench of the company law board before whom the petition is to be made. The petition must be accompanied with the following documents: evidence in proof of status of the applicant, affidavit verifying the petition, bank draft evidencing payment of application fee, memorandum of appearance with copy of the board's resolution or executed wakalatnama as the case may be. D. Class meeting. Class meetings are meetings which are held by holders of a particular class of shares. Example, preference shareholders. Such meetings are normally called when it is proposed to vary the rights of that particular class of shares. At such meetings, these members discuss the pros and cons of the proposal and vote accordingly. Class meetings are held to pass resolution which will bind only the members of the class concerned, and only members of that class can attend and vote. Number 2. Meetings of the Board of Directors. Meeting of the Board of Directors. Meeting of a committee of the board. Number 3. Other meetings. A. Meeting of debenture holders. A company issuing debentures may provide for the holding of meetings of the debenture holders. At such meetings, generally matters pertaining to the variation in terms of security or to alteration of their rights are discussed. Number B. Meeting of creditors. Sometimes a company, either as a running concern or in the event of winding up, has to make certain arrangements with its creditors. Meeting of creditors may be called for this purpose. In case of winding up of a company, a meeting of creditors and of contributories is held to ascertain the total amount due by the company and also to appoint a liquidator to wind up the affairs of the company. The following conditions must be satisfied for a meeting to be called a valid meeting. It must be properly convened. The persons calling the meeting must be authorized to do so. Proper and adequate notice must have been given to all those entitled to attend. The meeting must be legally constituted. There must be a chairperson. The rules of quorum must be maintained, and the provisions of the Companies Act 1956 and the articles must be complied with. The business at the meeting must be validly transacted. The meeting must be conducted in accordance with the regulations governing the meetings. A meeting cannot be held unless a proper notice has been given to all the persons entitled to attend the meeting at the proper time, containing the necessary information. However, an annual general meeting may be called and held with a shorter notice if it is consented to by all the members entitled to vote at the meeting. Notice of every meeting of company must be sent to all members entitled to attend and vote at the meeting. Notice of the AGM must be given to the statutory auditor of the company. A notice may be given to joint holders by giving it to the joint holder first named in the register of members. A notice of meetings may also be given by advertising. In case of a company having a share capital, and in the case of any other company, if the articles so authorize, any member of a company entitled to attend and vote at a meeting of the company shall be entitled to appoint another person, whether a member or not, as his proxy to attend and vote instead of himself. Every notice calling a meeting of the company must contain a statement that a member entitled to attend and vote is entitled to appoint one proxy in the case of a private company and one or more proxies in the case of a public company, and that the proxy need not be a member of the company. A member may appoint another person to attend and vote at a meeting on his behalf. Such other person is known as proxy. Quorum refers to the minimum number of members who must be present at a meeting in order to constitute a valid meeting. A meeting without the minimum quorum is invalid, and decisions taken at such a meeting are not binding. The articles of a company may provide for a quorum, without which a meeting will be construed to be invalid. Unless the articles of a company provide for larger quorum, 5 members personally present, not by proxy in the case of a public company, and 2 members personally present, again not by proxy, in the case of a private company shall be the quorum for a general meeting of the company. The chairman is the head of the meeting. Generally, the chairman of the board of directors is the chairman of the meeting. If there is no chairman, or he is not present within 15 minutes after the appointed time of the meeting, or is unwilling to act as chairman of the meeting, the directors present may elect one among themselves to be the chairman of the meeting. His duties include the following. He must ensure that the meeting is properly convened and constituted. That is, proper notice has been given, that the required quorum is present, and so on. He must ensure that the provisions of the Act and the articles in regard to the meeting and its procedures are observed. He must ensure that business is taken in the order set out in the agenda, and no business which is not mentioned in the agenda is taken up unless agreed to by the members. He must impartially regulate the proceedings of the meeting and maintain discipline at the meeting. He may exercise his powers of adjournment of the meeting should he in good faith feel that such a step is necessary. The chairman has the power to adjourn the meeting in case of indiscipline at the meeting. He must exercise his power to order a poll correctly and must order it to be taken when demanded properly. He must exercise his casting vote bona fide in the interest of the company. Initially, matters are decided at a general meeting by a show of hands. If the majority of the hands raise their hands in favor of a particular resolution, then unless a poll is demanded, it is taken as passed. Voting by a show of hands operates on the principle of one member, one vote. However, since the fundamental voting principle in a company is one share, one vote, if a poll is demanded, voting takes place by a poll. Before or on declaration of the result of the voting on any resolution on a show of hands, the chairman may order suo motu, that is of his own motion, that a poll be taken. Motion means a proposal to be discussed at a meeting by the members. A resolution may be passed accepting the motion with or without modifications, or a motion may be entirely rejected. A motion on being passed as a resolution becomes a decision. A motion must be in writing and signed by the mover and put to the vote of the meeting by the chairman. Only those motions which are mentioned in the agenda to the meeting can be discussed at the meeting. Amendment means any modification to a motion before it is put up to vote for adoption. Amendment may be proposed by any member who has not already spoken on the main motion or has not previously moved an amendment thereto. There can be an amendment to an amendment motion also. A motion must be in writing and signed by the mover and put to vote of the meeting by the chairman. Resolutions mean decisions taken at a meeting. A motion with or without amendments is put to vote at a meeting. Once the motion is passed, it becomes a resolution. A valid resolution can be passed at a properly convened meeting with the required quorum. There are broadly three types of resolutions. 1. Ordinary resolution. An ordinary resolution is one which can be passed by a simple majority. That is, if the votes, including the casting vote, if any, of the chairman, at a general meeting cast by members entitled to vote in its favor are more than votes cast against it. Number 2, special resolution. A special resolution is one in regard to which is passed by a 75% majority only. That is, the number of votes cast in favor of the resolution is at least 3 times the number of votes cast against it, either by a show of hands or on a poll in person or by proxy. Number 3, resolution requiring special notice. There are certain matters specified in the Companies Act 1956 which may be discussed at a general meeting only if a special notice is given regarding the proposal to discuss these matters at a meeting. A special notice enables the members to be prepared on the matter to be discussed and gives them time to indicate their views on the resolution. The company must within 7 days before the meeting give the notice of the proposed resolution to its members. Generally, the board of directors prepare the agenda of the meeting to be sent to all the members of the meeting. A member by himself has very little say in deciding the agenda. There are provisions in the Companies Act which enable members to introduce motions at a meeting and give prior notice of their intention to do so to all other members of the company. A copy of each of the following resolutions along with the explanatory statement in case of a special business and agreements must within 30 days after the passing or making thereof be printed or typewritten and duly certified under the signature of an officer of the company and filed with the registrar of companies who shall record the same. Adjournment means suspending the proceedings of a meeting for the time being so that the meeting may be continued at a later date and time fixed in that meeting itself at the time of such adjournment or to decide later on. The majority of members at a meeting may move an adjournment motion at a meeting. If the chairman adjourns the meeting ignoring the views of the majority, the remaining members can continue with the meeting. The chairman cannot adjourn the meeting at his own discretion without there being a good cause for such an adjournment. Postponement of a meeting means deferring the holding of the meeting itself at a later date. Postponement is done by the board of directors or by the person convening the meeting. In case of adjournment, it is the decision of the majority of the members present at the meeting itself. Dissolution of a meeting means termination of a meeting. The meeting no longer exists once it has been dissolved if within half an hour after the time appointed for holding a general meeting, the quorum is not present. The meeting shall stand dissolved if it was called on by requisition by members. Every company must keep minutes of the proceedings of general meetings and of the meetings of the board of directors and its committees. The minutes are a record of the discussions made at the meeting and the final decisions taken thereat. Every company must keep minutes containing details of all proceedings at the meetings. They have to be written directly on the numbered pages. Pasting or attaching of papers is not allowed. Let us quickly now summarize what we have learned today. We have learned about the directors who may from time to time entrust to and confer upon a managing director or whole-time director for the time being saved as prohibited in the Act. A managing director means a director who is entrusted with substantial powers of management which would not otherwise be exercisable by him. There are two types of meetings: meetings of members and meeting of board of directors. In case of a company having a share capital and in the case of any other company, if the articles so authorize, any member of a company entitled to attend and vote at a meeting of the company shall be entitled to appoint another person, whether a member or not, as his proxy to attend and vote instead of himself. The script also involves description about quorum, which refers to the minimum numbers of members who must be present at the meeting in order to constitute a valid meeting. A meeting without the minimum quorum is invalid and decisions taken at such a meeting are not binding. The chairman is the head of the meeting. Generally, the chairman of the board of directors is the chairman of the meeting. Motion means a proposal to be discussed at a meeting by the members. A resolution may be passed accepting the motion with or without modifications, or a motion may be entirely rejected. A motion on being passed as a resolution becomes a decision. Amendment means any modification to a motion before it is put to vote for adoption. Amendment may be proposed by any member who has not already spoken on the main motion or has not previously moved an amendment thereto. Resolutions mean decisions taken at a meeting. A motion with or without amendments is put to vote at a meeting. Adjournment means suspending the proceedings of a meeting for the time being so that the meeting may be continued at a later date and time fixed in that meeting itself, at the time of such adjournment, or to be decided later on. Postponement of a meeting means deferring the holding of the meeting itself at a later date. Postponement is done by the board of directors or by the person convening the meeting. In case of adjournment, it is the decision of the majority of the members present at the meeting itself. Dissolution of a meeting means termination of a meeting. The meeting no longer exists once it has been dissolved if within half an hour after the time appointed for holding a general meeting the quorum is not present, the meeting shall stand dissolved if it was called on requisition by members. Every company must keep minutes of the proceedings of general meetings and of the meetings of board of directors and its committees. The minutes are a record of the decisions and the discussions made at the meeting and the final decisions taken thereat. Hope you have understood the concept of the managing director and whole-time director, about company meeting, kinds, quorum, voting, resolutions and minutes. That's all for today. We'll be back with